So still with us, we have criminal defense attorney Lauren Zimmerman and constitutional lawyer Jeff Lewis. I see you, Jeff, nodding your head. Okay, what's on your mind?
Well, look, this is a classic reason of why the Supreme Court exists, to resolve conflicts among the lower courts and to clear up some confusion. Some of the questions out of the gate from the justices spoke about whether we should even be recognizing a malicious prosecution claim in this context. So it'll be very interesting to see what the justices do with this case.
Lawrence, what are your thoughts, especially about this argument for the respondent?
Look, I do criminal defense, so I love the fact that the opportunity that people who are wrongfully searched and their property wrongfully seized have an opportunity to prosecute a claim against law enforcement, because you have this judicially created Leon good faith rule, and a lot of stuff, people get bad search warrants and all this stuff is taken. So it'd be good to really see something that would maybe sort of tamp down some of the bad search warrants we've seen executed over the years. That's just sort of my personal opinion there.
Yeah, understandably. Jeff, yeah, obviously there's so much legalese and they get into a lot of minutia when they're having these arguments, but big picture, why is this so important to constitutional rights?
Big picture, this case presents whether or not it's easier or harder for someone to sue the police for misconduct. And the resolution of this case will require a criminal defendant either to affirmatively prove he wasn't convicted because he's innocent, or merely that he won the prior case, that he wasn't convicted, and no showing of innocence. And that'll have profound impacts for the number of malicious prosecution claims or similar claims that are filed in our courts.
So, Lawrence, obviously you're a criminal defense attorney. What kind of recourse do you or would you pursue for clients who have had such violations of their constitutional rights?
Sure. Well, in 1983 action, like Jeff said, I mean, for me, I think obviously the hard thing here, if they set the burden as you have to prove you're actually innocent, almost like, Justice Rehnquist said years ago when it came to proving, when it came to DNA cases and stuff, and exonerating you, that's a very high road to get to. So I hope that's not where they fall, because it's almost an impossibility to try to prove your innocence. The police are supposed to do a job a certain way. They have to have evidence, and probable cause is a very low standard. So if they didn't have probable cause, what more do you need? I mean, let's get real here.
Yeah. Okay, Jeff, I just want to get your final thoughts, because we do a lot of criminal cases here, and so we do have a lot of criminal attorneys on. Now that we have a constitutional expert, what are some of the major takeaways we should think about here?
Well, I'd be concerned about the comments or questions by Justice Breyer, as a member of the liberal wing of the court. He asked a lot of questions suggesting he's concerned about the impact on the docket, the number of malicious prosecution actions that are filed. And so if he's concerned, that suggests to me that there's one less vote in favor of allowing these types of plaintiffs to go forward with their case. So I'd be concerned if I was a member of the plaintiffs' bar in this case.
Got it. Well, thank you so much for your insights and analysis. Constitutional lawyer Jeff Lewis and criminal defense attorney Lawrence Zimmerman joining us tonight.